February 26th, I presented a motion, request for motions to transfer, for leave to file for new trial, for consolidation of cases, and for confirmation. Motion to transfer. Plaintiff Charity Colleen Krause requests the Northern District of Texas U.S. District Court grant motion to transfer out of court of magistrate judge for civil consideration and into court of presiding judge, granting leave to file motion for new trial in a criminal proceeding. Per local criminal rules 57.3 for case number 3:20-CV-00113-X-BH and case number 3:20-CV-00114-N-BH. Request for leave to file motion for new trial. Plaintiff Charity Colleen Krause requests the Northern District of Texas U.S. District Court grant leave to file motion for new trial per Rule 33 of the Federal Rules of Criminal Procedure for case number 3:20-CV-00113-X-BH and case number 3:20-CV-00114-N-BH. Motion for consolidation of cases. Plaintiff Charity Colleen Krause requests the Northern District of Texas U.S. District Court to grant motion for consolidation of cases per Rule 13 of the Federal Rules of Criminal Procedure for case number 3:20-CV-00113-BH and case number 3:20-CV-00114-BH. Request for confirmation and informal leave to file. Plaintiff Charity Colleen Krause requests confirmation of informal leave to file per Local Criminal Rules 47.3, as well as official and formal instruction on how to comply with Local Criminal Rule 49.1 for filing of criminal cases. At this time, no conference is possible under Local Criminal Rule 47.1a, as neither have attorneys for respondents been named, nor have respondents affirmed their intent to represent themselves pro se. Statement of case. Plaintiff Charity Colleen Krause requests leave to file motion for new trial in consideration of numerous violations of appropriate court procedure and in light of new evidence which has become available since Krause's first efforts to file on September 24, 2019, that were most recently denied justice on February 14, 2020. Krause contended in her original request for leave to file motion for new trial, case number 3:19-CV-02280K, that a new trial was being requested concerning repeated abuse of the electronic filing and other filing processes via the Supreme Court of Texas, as well as the Southern District of Texas U.S. District Court for going on what had been over 2 years at the time of the original filing of the Northern District U.S. District Court. Krause sought assistance with exercising her rights to due process after she was kidnapped for 10 days under the auspices of a, quote, mental health observation, end quote, that was issued as retaliation for her efforts to report fraud and child abuse at a domestic violence shelter in Pasadena, Texas. Since the time of Krause's first effort to report fraud and child abuse to mandated reporters at Neuropsychiatric Center in Houston, the state of Texas has closed down 3 separate facilities alleged to treat children with mental health issues for acts of child sex abuse and other child abuse. Krause has been refused any assistance throughout this time, while substantial personal property has been stolen. Krause has also been repeatedly retaliated against, including via abuses of the electronic filing system and other electronic accounts connected to her efforts to report on numerous local, state, and federal agencies. While she has witnessed the crimes with which she was trying to report escalate with thus far no intervention. During this time, Krause has also witnessed how her legal and reporting efforts have been used as derivative efforts in other legal proceedings, as well as for financial gain of others who have been availed of the benefits of Krause's stolen property and misappropriation of her efforts to report fraud and other crimes. Krause found more proof of the abuse of the court system in connection with her case following the denial of Krause's right to proceed pro hoc vis by Magistrate Judge Irma Carrillo Ramirez in case number 3:20-CV-00113-X and case number 3:20-CV-00114N. Krauss is already on the record in acknowledging that a specific appearance of a conflict of interest in the association of her reporting efforts with specific name classifications is actually part of the pattern of racketeering activity. Krauss contends that there is now a preponderance of evidence to demonstrate that this manipulation of the reporting and legal process was actually a premeditated effort to traffic Krauss as retaliation for her whistleblower efforts and in an effort to compel her to relent on her investigation. In addition, recent changes to Texas laws concerning access to public information have now served to intentionally violate many important reporting deadlines in consideration of sureties connected to response timelines, while also making any information on these acts of default, quote, confidential, end quote. Krauss understands specifically that changes to Texas laws regarding, quote, ethics, open government, end quote, concerning exceptions to case information connected to verdicts involving political subdivisions is in fact evidence of a conspiracy to commit crimes and to obstruct accountability for past crimes. Ramirez versus Texas State Board of Medical Examiners, number 03-02-00424-CV, was decided by the Court of Appeals in Austin on February 27, 2003, unbeknownst to Krauss. On April 6, 2017, Krauss filed with what was at that time identified as the Texas Board of Medical Examiners, but was shortly thereafter referred to resubmit to the Texas Medical Board grievances concerning interactions with mandated reporters in Texas hospitals that, among other things, violated laws concerning the legal prescription and distribution of psychotropic medication, as well as their refusal to assist with efforts to report child abuse. Krauss's grievances were denied any standing after the deadline by which to appeal the original order for protective custody had expired. Krauss has now been denied any assistance with exercising her rights to due process in this matter for what will be 3 years as of March 28, 2020, which is the 3-year anniversary of what was supposed to be the hearing to challenge the original order of restraint. As Krauss recounted in a report to the Texas State Auditor, report number 17-1588 of April 27, 2017, Krauss was told by the staff at West Oaks Hospital that they would have assisted her by providing transportation to the March 28, 2017 hearing to challenge the order of restraint, but were under no obligation to assist her with the April 3, 2017 hearing to challenge the order of protective custody. Krauss was not discharged from West Oaks Hospital in violation of the doctor's order clearing her the day before until after 6 p.m. on April 3, 2017, and hence Krauss missed the hearing. The Texas Board of Medical Examiners was informed on April 6, 2017 of Krauss's grievances concerning numerous staff members as well as the hospitals themselves. Krauss learned shortly after her initial efforts to file grievances that the Texas Board of Medical Examiners had been, quote, renamed, end quote, to the, quote, Texas Medical Board, end quote, and was at that time being considered by the Texas Sunset Review Commission, as was the State Bar of Texas. Krauss had also filed a grievance with the State Bar of Texas after an attorney interviewed Krauss on site at West Oaks Hospital after 6 o'clock p.m. on March 28, 2017, and obtained Krauss's written confirmation that she intended to attend the April 3, 2017 hearing. Krauss's original petition for writ of habeas corpus, WR-87,139-01, Texas Court of Criminal Appeals, 2017, charges that Krauss was intentionally denied any due process so as to prevent an evaluation and judgment of her grievances during the period of the Sunset Review. This fit a pattern of intentionally obstructing Krauss's fraud reporting efforts involving the Department of Health and Human Services and the Department of Housing and Urban Development per their funding of domestic violence shelters with mandated grievance reporting and response procedures as a contingency of funding in Chicago, Illinois, while a $100 million lawsuit was pending with the state of Illinois. Krauss was not informed of this lawsuit until after she was compelled to flee Illinois and seek assistance in Texas in November 2016. Krauss contends that 1. Assignment of case number 3:20-CV-00113-X and case number 3:20-CV-00114-N to a magistrate judge for charges of this degree is inappropriate, as these are not, quote, minor offenses, end quote, suitable for review before a magistrate judge. 2. Assignment of both cases to the same magistrate judge is a conflict of interest and in violation of the expectation of conduct explicated in Dondi Properties Corporation versus Commerce Savings and Loans Associations, 128 Federal FRD 284, Northern District of Texas, 1988. 3. No legal basis exists for willful violation of Krause's rights to due process by repeatedly denying her a legal reporting process, legal evidence submissions process, legal counsel including in the form of interview with a district attorney, prosecutor, or lawyer, legal closeout reports on open investigations that have not been responded to within legally mandated reporting periods, while the laws governing the reporting bodies of concern have been changed. No access to a means by which to provide herself with income, does not attempt to extort her into agreement to commit illegal activity, including in the form of accepting, quote, kickbacks, end quote, connected to former reporting efforts now repackaged as, quote, contracts, end quote, or, quote, offers, end quote, that attempt to extort her into agreement to assist others with attaining, quote, kickbacks, end quote, and no way to proceed in via judicial process without having to agree to pauperdom in lieu of being provided assistance or personal income so as to be able to pay filing fees or court costs, which are necessarily substantial in consideration of the need. 4. That the actions of Judge Irma Carrillo Ramirez are further indicative of the use of Krause's filings in derivative actions, despite Krause's express request in her request for disciplinary action, per reference to her original request for leave to file motion for new trial, that such not be done and why. 5. That evidence of this is that no instruction concerning, quote, special orders, end quote, is available per the local civil rules of the Court for the Northern District of Texas, U.S. District Court, but can be found in the local criminal rules of the court. And 6. That the failure to provide Krause timely access to her rights to due process and habeas corpus relief in this manner has aided and abetted violations of Krause's rights concerning perpetuities per Section 26, perpetuities and monopolies, primogeniture and entailments, as well as Section 12, habeas corpus, and Section 13, excessive bail or fines, cruel or unusual punishment, open courts, remedy by due course of law, of the Constitution of the State of Texas. While these speak specifically to the Constitution of the State of Texas, it was for violations by the Texas judiciary of the Constitution of the State of Texas that Krause originally sought remedy through the federal district court system, and it is in accordance with the violations of these rights that the pattern continues to be perpetuated as the reference to the specific case herein attests. This violation of Section 26 of the Texas Bill of Rights and the means through which it was accomplished in the Northern District of Texas U.S. District Court now represent the second violation in less than 10 years. The recent discovery of the case information regarding Ramirez versus Texas Board of Medical Examiners, as well as numerous other cases, demonstrate that the pattern of racketeering activity with which Krause has been trying to seek assistance in prosecuting involves similar violations of the Constitution of the United States, including in commission of crimes going back more than 2 decades, specifically and demonstrably evident in regards to Krause herself as the primary, quote, vehicle, end quote, through which these crimes have been committed. Under federal RICO statute, a conspiracy can be demonstrated via the use of the same, quote, vehicle, end quote. In association with the attendant acts of securities fraud is consideration of Krause's efforts to report on allegations of securities fraud involving a brokerage with the same surname as the attempted magistrate judge of concern in case number 3:20-CV-00113-X-BH and case number 3:20-CV-00114-N-BH, as well as other persons. The connection with the allegations of fraud has already been established in several legal filing efforts, including ones sent to the Supreme Court of the United States, as well as the Supreme Court of Texas. These allegations go all the way back to Krause's efforts to exercise her right to ordinary political process when she attended city council meetings in Chicago in April 2016, following efforts to contact local aldermen with requests for information connected to municipal water bonds. That was itself a follow-up to several articles Krause had published in the fall of 2015 as a journalist covering issues connected to water access and proposed water-related projects in the San Francisco Bay Area and other parts of California before traveling to Chicago, Illinois in December 2015. As such, there is overwhelming evidence that the assignment to a magistrate judge and efforts to repeatedly and with strategic timing attempt to do so should be considered for their potential culpability with the allegations first submitted on September 24, 2019. The nature and duration of these crimes are significant enough to warrant transfer out of a court of civil consideration and into a court for criminal prosecution. As such, Krause requests leave for file leave to file motion for new trial and granting of the hearing requested motions. Cross additionally requests leave to file indictment under seal per local criminal rules 553.55.3b1. Oath of attestation. This was finished by 10:11 a.m. Central Standard Time on February 26, 2020. I submitted it the same day. I am sad to say that the response I got was not appropriate, and by April, I would have been within an appeal period and could have presented an appeal. However, the actions that had been engaged in response to this by the members of the federal district court called into question the wisdom of pursuing that course at that time, as I understood that to do so would be to continue participating in what was obviously egregious breach of practice concerning not only the local rules but the overall federal rules of criminal procedure, including the federal rules of civil procedure, including the ones that were first cited in the original filing effort.